So next we have, I don't have my schedule right here. Paul, yeah, come on up, Paul. Next we have Paul Taylor, who's going to come and speak to you about injured workers or people with disabilities. Thank you.
No, thank you. Hey, everybody. My name's Paul Taylor, as you can see. A little bit thinner in that picture. Goes to the right, Ellen? To move, goes to the right? Oh, okay. Yeah. Oh, there we go. So I wrote a paper, sort of like I was fancy, smart person, and I broke the paper down into 4 sections, who I am and what I've done, because in my personal opinion, I'm thinking like the WSIB president, it's all about me and not you. So I figured I'd tell you what I have done and who I am and the significance. And one of the reasons is that I'm an injured worker. I'm also an injured worker advocate. I'm a legal person, but I'm also at school studying labor studies, so I have a wide background for some weird reasons, just how my life has went. Another insignificant and very important thing is the history of workers' compensation in Ontario, because that's what started it all. And I want to go back, very briefly I want to talk about it, but I want to go back before Meredith, because to me, in my personal opinion, it is extremely important people remember that. And then the legal risks of forced return to work and the importance of knowing your rights as a person with disabilities. So who I am, prior to being injured, I worked in the Canadian military, but before then, I was a person that had a disability of color vision. I was partially colorblind. 3 out of 10 men are colorblind. So when you look at those color circles, you should be able to see numbers. I can see the 8, and I can't tell you what the top right number is. So that's my color vision. That's how they test color. So the interesting point about that little test is it's subjective. It's meaning what I say. So in dealing with the compensation officials and employers, in my experience, in my 30 years, in dealing with them, that's an invalid test. So you're wasting your time with them. What was funny about the disability all my life and dealing with disabilities is when I went to join the Navy said, you can't because you're partially colorblind. When I joined the Army, the doctor said to the other doctor, well, all he's going to see is red and green. What does it matter? And I laughed. And then I realized later that actually wasn't funny. So then I moved on in life and I became a truck driver. So that was me on the right. I was actually, wow, I do actually look pretty good there. We were pretending to be lost when we picked up a load. On the left of 2 pictures, that's when I worked at Canadian Tire. That was typical work. And what was funny is I worked for a temp agency who I worked for Canadian Tire. I did all my work for Canadian Tire. They dispatched us out. I never talked to my, so to speak, employer ever. Same with all the other drivers. We would often joke and say, how is it temporary when we've worked here for 5-6 years and we work an average of 80 hours a week? So there is no temporary nature to it. And as you can see, it's very physical work. The real twisted part of my mindset is they used to put everything on skids, but somebody said, we'll save money by putting it this way. Well, of course they're going to save money because they transfer the cost of work injuries onto the temp agency. There was 3 things I realized about dealing with temp agencies. One is they can write off the payroll cost. The other was work injuries. They don't have to worry about them. They're a nice, safe employer. And the third one is there's no labor disruption. I don't like the look of you, don't come back. And I've literally heard them say that when they didn't like the look of a worker, female worker, or even minorities. It's funny because now the company is pretty much staffed with all minority employees. Oh, the irony. So initially, when I was injured, I suffered a long-term permanent injury, and the WSIB, in its infinite wisdom, sent me for retraining. And the reason why I say that, they said I was going to be retrained as a network engineer, and that course was a 1-year college course. What was funny is the job requires somebody to be able to tell colors apart. So that course literally blew up. So on my own, I then, after a few years, I went back to school and went to Sheridan College, and I took marketing because I really liked it. And then I transferred to McMaster in their business program, And I made a cardinal sin of taking all the different courses, labor studies, political science, philosophy. And then I didn't like business anymore. I like labor studies, philosophy. So I switched programs. I think I'm on my third change, a major, I guess you'd say. Then I took a break and I became a paralegal, which a lot of my friends said, oh, that's you. And then recently I've found that studying, sorry, this stage really creaks, and I think it's the extra weight on it. So then I took human rights theory, which was a fascinating course. There was people from all over Canada there, and I'll tell you, I walked out of there knowing less than when I walked in. That's how the law seems to work. It really makes you feel small. And as I said, I'm still attending McMaster. So I just want to basically quickly go over the history of workers' compensation prior to Meredith. So prior to 1886, which was a significant time in Ontario, workers had to sue their employers for work injuries. Well, no surprise, according to a paper by Eric Tucker of Osgoode Law School, he researched all the cases and he found less than 15% of workers were successful. And the reason why was because what's called is the unholy trinity. These were the defenses employers could plead. Contributory negligence, you contributed to your work accident. Fellow servant, your coworker caused it, not the employer. And then the third one, assumption of risk. You assume the risk of your job when you started working there, something that I still to this day don't comprehend. The worst part is that in 1886, actually I'm jumping ahead, there we go. In 1885, in a munitions plant in Hamilton, Ontario, it blew up, killing 5 workers. Now, I admit to you, I can't verify this story. I've been trying to find the news article, but I'll find it one day. Because to me, it was very, very important, and it was a very pivotal time in history. It literally caused the whole province to stop and see workers, injure workers as people and say, enough. And it caused the Ontario legislature to remove those 3 defenses. From that, what happened was, from 1886, the workman, now this is not what it is. It says Workmen's Compensation for Injuries Act of Ontario, but it had nothing to do with compensating workers. What it really was an Employers' Liability Act. And what it did was remove those 3 defenses employers could make. But it didn't fully remove them. The third one, assumption of risk, it was still there. That's why workers were only 53% successful. Now, Professor Mavor, that's his picture, kind of scary looking, he wrote to the Ontario legislature raising this point saying, well, if 53% of workers are successful, 47% are not. And what happens to these workers? They become a burden to society, to their families, to friends. Right. This was an article that I took out of Butterworth's, and it was in a paper. And it said, basically, it talks about the realization of who should really pay for work injury. Should it be workers, or should it be the employers who are making the money? And then in 1910, most of us know about Sir William Meredith. He was the former Chief Justice and former Premier of Ontario. He was appointed to head the Royal Commission on Workers' Compensation. What's interesting to note is both Whitney, he was the Premier, and Meredith were both Ontario Conservative Party members. And I just say that because today Conservatives seem to be very negative towards Labour for some reason. Meredith was a very pro-socialist kind of person. So that was the name of his report. Why do they make it so long? I don't know. But it's a mouthful and a half. So he did 3 reports. His final report was a draft workers' compensation legislation. And then after he did that, the one thing that is often missed by people when they're talking about Meredith, you always hear Meredith principles. To me, in my opinion, this is the most important thing. If you want to make change in the workers' compensation system, this is what you've got to say. What is the significance of workers' compensation? And that is to prevent the cost of work injuries to be borne on the family, the friends, relatives, and most importantly, taxpayers, the community at large. Because when a worker doesn't get compensation, they go on Ontario Works, Ontario Disabilities Support, Canada Pension. That's all taxpayer funded. And that's something that's being deliberately missed by the government. Oops. So then Meredith, he created that purpose, and to maintain the purpose, he created these 5 principles. And what angers me is when you read Meredith back then, like when they said no fault, it meant no fault to the injured worker. Today, it's pretty much a fault-based system. Administration, the employers, the Canadian manufacturers, and the previous presenter was talking about how the manufacturers had a view on the issues. What's funny is back then, they didn't want a government-run board system because they felt it would be biased towards employers. Well, how is it today? Benefits. Benefits were supposed to last as long as the injury is. And now Ellen was just talking about turning 65. I'm scared as heck, because I'm going to be turning 65 sooner. And it's like, uh-oh, I'm going to have to buy a tent. And then remove of litigation rights. What was interesting is when you look at from the time when Meredith brought it in and he created the compensation law based on his principles and purpose, there was very little change until Wheeler's report. And what was so dramatic about the change was they split benefits into what's called as a dual, or in that case, a triple award system. But the most important thing was you're being paid for your injury, and then you're going to be paid if you can't go to work or not. And that was the dangerous thing, because that's where we are now with the return to work system. What was amazing was at that time, injured workers and advocates knew how bad this was. And I remember reading that it was one of the advocates, and I can't remember who it was the Union of Injured Workers, or anyway, convinced the Minister of Labor to send a notice to all injured workers in their pay stubs about this hearing. And they had over 3,000 injured workers attend Queen's Park. They ended up having to do the hearings on the steps. That's a picture from the event in 1983. John McKinnon was there, actually. I think he was with Meredith, actually. No, I'm just kidding. Oh, Carl, yeah, right. I always make fun of Carl. So what's funny is they did get what they wanted, is that the government at the time removed the dual benefit award system. But what was interesting, I noted, was they went from 70% of gross pay to 90% of net pay. And many people go, well, that doesn't matter. It does when the board is calculating the gross to net. Because how it works now is if you make $10 an hour, they'll say, okay, well, Willie, you're a single guy, so your CPP and taxes is $3, so we'll give you $7, 90% of that. But what if Willie had 5 kids and 2 wives or something? Then his tax rate is much lower, but they often don't factor that in. Then there is what's called as the disability tax credit that Revenue Canada gives people with disabilities. I've yet to meet an injured worker yet that the board has factored that in when they're calculating the gross to net income. So then what happened was in June 1988, the legislature slipped in Bill 162, and that was because Mike Harris got his way. And they created the dual benefit award system. Bill 99, I can't even say it. I have a hard time with it. It created the Workplace Safety Insurance Act, the board, and the Appeals Tribunal. Notice how they went away from workers' compensation to insurance. It's been this big push to insurance. And in fact, if you look at the compensation board and the people that are there, I believe it's actually 4 directors of the WSIB's board of directors are insurance people. It's all about insurance now. The government said at the time it was about prevention, fiscal responsibility, and getting workers back to work. I've argued with the WSIB in court many times, and they bring up fiscal responsibility. But ever since I slammed them and said, well, if you're saying that you're all worried about fiscal responsibility, why did you advertise the rebate during the 2022 election with injured workers' monies? Meaning you're not being very fiscally responsible. And since they don't mention that anymore. If you'll notice, the WSIB doesn't bring that up too often. So in talking about return to work, the most troublesome sections of the law are these here. That the worker must cooperate in early, safe return to work. As soon as I hear those words, I just kind of cringe. And that the WSIB is to decide any matter of suitability and safety in return to work. That's a pretty wide sweeping statement. My clicker isn't working. Oh, there it is. I'm not pressing hard enough. But then when you look at the Human Rights Code, Okay, I'm going to talk faster. I'll try. The code and every provincial human rights legislation has the same thing. In Alberta, it's Section 12. It has what they call as a primacy clause. It says that the code is primary over every other law, with the exception if that law says otherwise. So in Ontario, we like to discriminate against people with age. So Section 2.1 says age. So disability still applies. And now what's interesting in Ontario, the Human Rights Code, it goes beyond defining disability. What I love is Section E, an injury or disability for which benefits were claimed or received. So in other words, a good example is you have an injured worker with 3 areas of injury, the board accepts 1, so that's what they decide. But then in return to work, the board has to accommodate the other 2 as well, but they don't. A really good book, in fact, I would say across Canada to use when you're dealing with return to work and accommodation, is the Human Rights Commission of Ontario's Guide on Persons with Disabilities. This is an excellent book because it gives reference to Supreme Court of Canada and Court of Appeal cases. Injured workers, one of the biggest areas of concern is harassment, discrimination, and failure to accommodate. I'm talking fast, I apologize. In the accommodation process, it says that it's supposed to respect dignity, respond to a person's individual needs, and allows for integration and full participation. This is for the individual. Willie's laughing because he knows how the board does it. All compensation employers, that never happens. They tell you what your job is, and that's it. It doesn't meet that requirement. This is what the provider of accommodation, so if I went to Ellen and she's my boss and I said, I have a disability, I require accommodations, this is their rules according to the Human Rights Code. And notice how it says, if they have not made a specific or formal request, according to the Human Rights Code, if I don't make a formal request, but it's plain and obvious to Ellen it is, then it is though I made the request, and a complaint can be filed for it. This is more. So 3 areas of failure on workers' compensation is the return to work process, retraining, and during the appeal process. What I mean is when you attend a hearing, I've often heard of injured workers where if they have a busted knee, they literally have to use a garbage can to put the leg up. They won't accommodate it, even though they say in their literature. This is one of the statements that a vice chair at the Workplace Safety Insurance Appeals Tribunal said about accommodating persons with disabilities during the hearing. And they said, barring undue hardship or interference with the ability to run a hearing in an appropriate manner, the request will be generally accepted. What's funny is the code says undue hardship is the defense an employer or an accommodation can make, but the only exception, the only time they can make that is when there's a big cost factor. You know, it has to be spelled out. I'm going to try and go quicker. This was another one, and this was on a decision he made. He's talking about accommodating in return to work process, and he's saying you have to prove your disability and prove the connection of your disability to the workplace, which is completely wrong. And this comes from a vice chair. What's even more funny is this person wrote the book on workers' compensation. This is David Curtis. I want to quickly talk about his story. He was an injured worker. The board said that he was declared unemployable. That means he can no longer work till age 65. Then his employer did an investigation on him. He gave me permission to talk about his story. The board then charged him with 4 counts of misleading the WSIB. He was found guilty on 1 statement. He was ordered to pay a fine of $9,000 and a 25% victim surcharge. That should be a percentage, sorry. And he was put on 2 years probation. David Curtis was a religious pastor. He appealed, and it was overturned at the Court of Appeal for Ontario. I was there when the president of the panel turned around and said, it is not good enough that you took their benefits away, now you want to throw them in jail as well. They're going to that extreme. So I'm just going to briefly, I'm not going to talk about the risks of return to work because it's plain and obvious. And legal forum. So if you have like in the return to work process, you can bring up human rights at the WSIB appeals, at the WSIAT and when you're in court, small claims court and human rights tribunal. The problem where it gets confusing is how do you get your rights protected? There's confusion in the courts all the way up to the Supreme Court of Canada. They say first you have to win your benefits, then you can file a complaint for damages for them injuring your dignity and self-respect. However, the Supreme Court in 2009 said, no, to make somebody go through 2 legal processes is a denial of access to justice, and this is how you do it. But I say you have to go that route. There, conclusion. So basically, that's one of the biggest issues is finding that the board and employers are just not accommodating people with disabilities in the return to work process. Thank you. Sorry I was too long.
Thank you very much, Paul, for that really interesting coverage. So if anyone has any questions, the break's starting now, and so feel free, is that okay, Paul, if they come up to your table and ask you any questions up there? And then we'll just go for the break right now. So thank you to all the panelists, and we are now having a break. Thanks.